All right, good morning, everyone. Good evening to some of you, and maybe good afternoon. Before we start, I'd like to acknowledge Australia's mission to ASEAN Councillor Gillian Ray and other distinguished guests from Australia's Department of Foreign Affairs and Trade, logging in from Australia, Jakarta, and Bangkok. Australia, hi, good morning, Julian. ASEAN, Australia Counter-Trafficking Team Leader, Lucia Hyderpauli, ASEAN-ACT colleagues in Australia and across the ASEAN region. Speakers, His Excellency Wan Chai Rup Chanavong, Ms. Bunlua Chanta Poma, and Sarah Basil. Also with us today are government and non-government partners and anti-trafficking advocates in the ASEAN region and other parts of the world. Welcome to our 7th ASEAN-ACT webinar on adaptive justice responses on trafficking in persons under the new normal. We have around 700, more than 700 who registered, and we now have around 300 in the room, and we see more are logging in. I am Darlene Pajarito, Justice Systems Director of ASEAN-ACT, and I am your moderator today. And our ASEAN Program Director, Archimeda Siduan, will be our co-moderator for this webinar. For some webinar house rules, let us watch this video.
Hello. Thank you for joining us today. We would like to make this virtual event a pleasing and productive experience. To make this happen, the organizers request all participants to observe the following house rules. Display your full name and office. Please use the chat function to provide comments and the Q&A box to ask questions. The moderator will then read your questions to the panel. For documentation purposes, this event will be recorded and shared on our ASEAN-ACT Partnership Hub portal. Translation is available by clicking on the interpretation button and choosing your preferred language. At the end of the event, please take a few minutes to fill out the feedback form. As we are in a virtual environment, we will be kind to one another in case of internet connection issues. We will expect unavoidable technical difficulties. Feel free to join back if you're disconnected. Everyone's patience will be greatly appreciated. Thank you for your attention.
Just to add, for those who need to use the translation or interpreters channel, please make sure you have the updated room version 5.6. Our speaker from Laos will be speaking in her local language. So if you want to hear in English, please click on the interpreters function, then choose the English channel. Our other speakers will be speaking in English. If you want to listen in Cambodian, Khmer, Myanmar Burmese, Bahasa Indonesia, Thai, and Vietnamese, just click on its respective customized channel. But if you want to listen in Lao, please choose the Spanish channel for Lao translation. The materials from this webinar will be shared upon request. Now, to formally open our esteemed speakers, guests, and attendees, we are pleased to have Ms. Gillian Ray. Ms. Ray is counselor at Australia's mission to ASEAN. She is responsible for strategic policy settings and effective program implementation for ASEAN mission and investments. Councillor Gillian Ray, you have the floor.
Thank you so much, Darlene. Good morning, everyone, and welcome to our partners, anti-trafficking advocates, and all participants. I know that new waves of COVID-19 and the Delta variant are causing some incredibly difficult conditions for many people in our region right now, and I'm hoping and praying that everyone is safe and well at this difficult time. It's always a pleasure to open the ASEAN-Australia Counter-Trafficking webinar series and connect with officials and advocates from all over the ASEAN region. I would like to warmly welcome our esteemed speakers. His Excellency Wan Chai Ruchunwang, Thailand's representative for children's rights, ASEAN Commission on the Promotion and Protection of the Rights of Women and Children. Ms. Boonloo Chantupuma, Director General, Centre for Counselling and Protection of Women and Children, Central Lao Women's Union, Lao PDR, and Ms. Sarah Bessel, Director General, Human Trafficking Legal Centre, Washington, DC, USA, who will be formally introduced later in the program. Today's webinar is the 7th in a series of 10 webinars hosted by ASEAN-ACT. Our topic today is victim compensation and is particularly significant in the month of the World Day Against Trafficking in Persons, observed on 30 July each year. This year's theme, Victims' Voices Lead the Way, highlights the importance of listening to and learning from victims and survivors. Recognising trafficked victims as key actors in preventing and combating human trafficking is central to our discussion today. Australia is committed to continuing its 17 years of work with ASEAN partners to improve justice responses to trafficking, with a focus on protecting victims of trafficking and those who are vulnerable to trafficking in persons, especially women and children. Our shared commitment to combating trafficking in persons is one example of our long-standing partnership. Australia and ASEAN share a vision for a peaceful, inclusive and resilient region and a shared path to recovery from COVID-19. As ASEAN's longest standing dialogue partner, Australia is committed to supporting Southeast Asia in responding to the immediate impacts of COVID-19 and recovery over the longer term, ensuring the region remains stable, prosperous and resilient. We are with you every step of the way. Under our COVID-19 development policy, Partnerships for Recovery, we are turning this into real action, with our Foreign Minister and Prime Minister announcing unprecedented packages of economic, development and security support in 2020, all designed to support the region's recovery from COVID-19. Our support is focused on health security, stability and economic recovery, and is underpinned by a strong emphasis on protecting the most vulnerable, especially women and girls, from the impacts of the pandemic. We know that COVID-19 and the measures put in place to address it are exacerbating existing vulnerabilities and creating new ones. The pandemic will continue to impact trafficking victims and increase the vulnerability of some groups to trafficking, including women and children, migrant workers, and workers in the informal sector. In this context, the safeguarding of victims' rights, including the right to access legal remedy, is more important than ever. There are several key factors to consider in establishing and improving policies and systems to protect trafficked victims. First, victim identification is a gap in many jurisdictions. Compounding this gap, victims often lack access to vital support services and information, including information on the right to access compensation for damages they have suffered. When victims lack access to information, they are not able to make informed decisions about whether to participate in criminal justice proceedings. As victims are often the only witnesses to trafficking in persons cases, successful convictions often depend on their involvement. Despite the strong foundational guidance from international and regional instruments, including the ASEAN Convention Against Trafficking in Persons, especially women and children, most ASEAN member states have some way to go in developing and implementing effective systems for provision of victim compensation. Today, we are extremely fortunate to have a panel of experts who will discuss key aspects of victim compensation and the legal basis for claiming compensation in trafficking in persons cases. Our brilliant panel will share good experiences from other jurisdictions, as well as some of the challenges faced in administering compensation and how these can be overcome. We hope that today's conversation will stimulate an exchange of ideas and facilitate new connections between those working in the ASEAN region and on improving access to compensation for victims of trafficking. And on a final note, I must raise Australia's grave concerns about the situation in Myanmar. Australia supports ASEAN's crucial role in responding to the situation. ASEAN-led efforts represent tangible steps to ending the violence in the commencement of a dialogue between all parties concerned. We reiterate the importance of the full and timely implementation of the 5 points of consensus agreed by leaders in April. We call for the immediate release of those arbitrarily detained, including Professor Sean Turnell. Again, I welcome everyone to today's ASEAN-ACT sponsored event, and I look forward to an insightful discussion. Thank you very much.
Thank you very much, Councillor Gillian, for the warm welcome and inspiring remarks as always. It is very energizing to know about DPAD's continuing commitment to its work in the Southeast Asia and the ASEAN region with our ASEAN partners. Continuing our collaborative support is indeed crucial to improve counter-trafficking justice responses and protecting victims' rights amidst the pandemic that the world continues to experience. Okay, for the most important part of the webinar, let's have a group photo. May we request everyone to please put on your camera. Cam will give us the cue.
Thank you so much, Terry. May I request our panelists, our team leader, Lucia, to kindly switch on your video cameras. Okay, and please give us a good smile. And look at your cameras, and I'm going to take a screenshot in 3, 2, and 1. Okay, there you go. Now let's do the waving pose. Ladies and gentlemen, if you may, kindly wave like this in 3, 2, and there you go. Thank you so much, ladies and gentlemen. Back to you, Pauline.
Perfect. Thank you, Cam, and everyone for your big smile. Okay. Given our topic today on compensation for victims of human trafficking, good practices and challenges, you must have some burning questions on how compensation is obtained in other jurisdictions and where funds for victims' compensation is sourced and the like. We hope to answer your questions with our panel of experts on the subject matter, who will discuss the key concepts underpinning victim compensation and related matters from different perspectives. So before we invite our first speaker on the floor, we would like to draw out some thoughts from our webinar attendees. We now have 350 of you now. Cam will display on the screen the poll questions. May we request our attendees to please take a moment to answer the questions. There is no right or wrong answer, and attendee identification is not required. So for purposes of translation, I will read the questions out loud. Poll question number 1, victims have a right to appropriate compensation. Should compensation be dependent on victims pursuing a legal case against the perpetrator? Yes, no, somewhat. Some victims refuse or are unable to testify for a range of reasons. Should victim compensation be dependent on the criminal conviction of the accused? Yes, no, somewhat. One way to claim compensation is through a state fund. Do you think there should be a regional standard to claim compensation from a state fund? Yes, no, somewhat. So you may continue putting in your answer. This will be quick, just 3 clicks and you're done. We will present the poll answers after the presentation of our 3 esteemed panelists. Okay, just keep it coming. And then we move on to the introduction of our first speaker. Okay. Let me now introduce our first esteemed speaker from Lao PDR. To discuss on the topic from the perspective of the government, we are very fortunate to have with us Madame Bunlua Chantapoma. Ms. Bunlua is the Director General of the Counseling and Protection Center for Women and Children, Lao Women's Union. She has been working at the center for 15 years, which was also around the same number of years the center had been established and is in operation. The center provides comprehensive assistance for women and children, survivors of trafficking in persons, domestic violence, and sexual abuse and exploitation. Ms. Bunlua is also concurrently serving as the deputy head of the Secretariat of the National Anti-Human Trafficking Committee. Ms. Bunlua, you have the floor.
Good morning, distinguished participants. First of all, my respect go to Julian Lee, Australian counselor to ASEAN, dear Rusia Pedro Pauli, team leader ASEAN-ACT, and your team, Excellency Wansai Ruchanavong, dear Zara Bezo, Director, ladies and gentlemen, attending today's webinars. Today, I have a great honors and very pleased to be able to attend, as well as to have John to share some lessons in the topic compensations for victims, the best practice, and the challenges facing by Lao PDR. My sharing today, I will share 5 or 6 or 7 points starting from our mandates until the challenges that we have experienced. First, the mandates of the Center for Counseling and Protection of Women and Children in brief. Center for Counseling and Protection of Women under Lao Women Union. We are one of the institutions under Lao Women Center Lao Women Union. We are mandated to provide legal advice, give counseling for physical and zygo for women and children who are suffering from family and social problems. We also receive the case or reporting or mediating issues related to the legitimate rights of women and children. We also the guardian for protecting women and children, the victim or any children who are abused. And we also represent them in the case proceeding without any claim. And then we also provide necessarily the sick aspect of support to the victim of different of abuse and violence, for support the victim of trafficking based on Article 64 of the laws on anti-trafficking. Lao Women Union are accountable for searching for a safe temporary shelter, and also provide physical rehabilitation, basic care services, provision of short-term vocational training, provision of counseling, legal advice, protection, the legitimate rights and benefits of victim of trafficking, to prepare the victim based on the process defined in the case proceeding, and also represent them in the court, as well as refer them to reintegrate to their family and society. Second, for the victim assistance through what we call one-stop services, and especially claim for civil compensation based on the mandate as representing, to protect the legitimate rights and benefits of the victim and those who are. And so we take the complaint to address or to mediate the legitimate right and benefits of women and children, so we can fulfill to claim for the civil compensation for the victim of TIP based on Article 64 on combating law on combating trafficking in person. Thirdly, basic step in claiming the civil compensation for victim of trafficking. So for the law on criminal procedure, the injured person or representative shall have the right to make a request for compensation thanks to the criminal procedure law, and also to claim for the civil compensation for trafficking in person victim before law, Article 103 of the law on criminal procedure law, version 2017. And We also, based on Article 36, request for civil compensation or based on the law on anti-trafficking in person stated that the victim or civil plaintiff have the right to claim for civil compensation during the criminal proceeding, meaning that claiming for civil compensation can be requested at any status of criminal proceeding. However, for the legal assistance practice at the Center for Counseling and Protection of Women and Children, first, we are the legal representative in legal proceeding as well as request for civil compensation, and then we need to collaborate with all justice agencies, law enforcement officers to provide guidance or counseling to support the victim in the process of legal proceeding, to prepare the victims for legal proceeding processes. In case that the victim are not do not know the language, we seek the translator, interpreter, as well as to translate legal document for them to understand. For complaining of civil case, we have two forms. The first form, we try to mediate with the accused person at the local level if they can reach agreement by both parties, so that mediation can be worked. We just make the memos to take the monetary compensation. Second form, we file the request for compensation to the court based on the laws. So after the court make judgment, when the judgment can be fully enforced, and then we will implement it. Number 4, during the pandemic of COVID-19, and according to the question whether we have any policy or procedure have been changes for claiming the civil compensation for the victim. Now, in terms of policy and law, it has no changes, meaning that the victim still requests for civil compensation or compensation as what have been defined in the laws as before. Number 5, I just would like to share with you all some best practice, some case studies, and what are the factors that enable, civil compensation. So the case study I want to share with you, Miss Dukta, pseudonym 13 years old. She's from the poor family. The primary occupation of this family, they are do the slash and burn activity. However, she would like to have the school uniform. Therefore, during the summer holiday, Tukta, the girl's name, okay, has worked with her older sister in one restaurant in Vientiane capital in order to get some money to buy the new school uniform. When Tukta came to Vientiane, the owner of the restaurant asked her that, do you want to get the money to buy the new school uniform, right? Tukta responded yes. Therefore, Miss Buakam, who is the owner of the restaurant, brought Tukta to the guest house to provide service to a guest where Miss Buakam made appointment from such guilty. Tukta had serious injury, and then she was referred to the hospital, or she was hospitalized, and then the doctor have coordinate with us, and the police provide support to Tukta, and especially her older sister requested our center to be to represent them in the legal proceedings. So in this case, we conduct the criminal proceeding in the trafficking in person case and claim for compensation. So we have start from the taking testimony, interview, and request the compensation and join the mediation with the relatives of the perpetrators. After mediation, and we could agree, both parties could reach agreement. The perpetrator is pleased to pay civil compensation of 60 million gib to Tukta. Therefore, we also organize handover of the money, joining or witness by the local authorities. And then we have sent this memo on receiving this. We send it with other, case file to the court. However, the factor making victims to receive civil compensation, first we need to give counseling, to provide legal advice and the process of criminal procedure process, so that they are aware of their rights. What are legal rights? Second, we interview to get detailed information on the development of the situations to this victim. It will be the good basis for claiming the compensation, because we will know the level of the damage, how severe the case is. Thirdly, the ownership of those who protect and provide support to the victim of trafficking in person, particularly provide legal advice, so that the victim will receive will enjoy their right as has what have been stipulated in the laws, and then also create enabling environment for the victim to get access to claiming for compensation or damages. That's to corroborate and to engage of all multi-stakeholders who have the role to provide legal support. And it is very critical to make the claiming for civil compensation or compensation to be successful. Another aspect which are important that cannot be missing, we need the engagements of the victim themselves, that they provide good cooperation with the authorities. Without their cooperations, we cannot proceed or claim for compensation for the victim. Number 6, of course, we still have challenges for requesting for civil compensation. What we have experienced, there are 3 main things that we have experienced, and then we can learn from this. Firstly, the legal proceeding, it take a long time, and there are many processes. Therefore, claiming for civil compensation find difficulties, particularly the cases happening abroad. So, for the case to be finalized or to be completed, in case looking for the victim to be informed of the compensation amount, some of them have resettled from the original village to somewhere else. Therefore, we could not track or we could not find the victim. Secondly, filing the document, supporting document for claiming compensation or civil compensation, as well as the process and procedure to receive compensation or civil compensation in cases the cases happen abroad or in other country, because it's time consuming and this is because, and we have bilateral cooperation. We have to have go back and forth. Even though you have full document to receive civil compensation, some cases the document also take time to reach the destination. It take a few months. Sometimes it's expired. You need to reformulate the documentation again. Second is the enforcement of the court decision claiming for civil compensation. It is very difficult as well, because the perpetrators do not have property or proceed to pay for this compensation to the victim. And point number 7, we would like to recommend how to improve the claiming for civil compensation. First and foremost, we need to enhance the coordination between and among stakeholders who have the role to play in anti-trafficking, both public, those also both the judicial justice, the prosecution, and victim protection organization both in Laos and abroad, so that we can protect and the victim can benefit based on what have been defined in the law. Next, next recommendation, we need to pay attention to raise the awareness on the protection on the legitimate rights and interests of the victim of trafficking. Particularly, they need to understand the processes of compensation or civil compensation, both within the country or in abroad, for the concern or relevant organization who are in the areas, to make sure that the victim will receive compensation, civil compensation, as what have been defined in the law. That's all for my presentation to share with you. And if distinguished participant, if you have any thoughts or if you have any doubt with regard to my presentation, feel free to comment and question. Thank you. During the Q&A session. Thank you very much.
Thank you very much, Madam Bunlua, for the excellent presentation and sharing with us the Lao experience. It is really refreshing to know about the work of the center and how it helps traffic women and children in the legal proceedings and obtaining compensation for them. We agree with you that indeed communication and coordination with relevant stakeholders are key to helping victims obtain compensation and also to improve the processes. All right, thank you again. Let me introduce our second speaker. Who will discuss on the topic from a regional perspective. His Excellency Wanchai Ruchanavong is Thailand's representative for children's rights of the ASEAN Commission on the Promotion and Protection of Women and Children. He is a senior consultant public prosecutor who began his legal career in 1975. He led various departments of the Office of the Attorney General and the Ministry of Justice as director of the following departments: Child and Juvenile Observation and Protection, Probation, Correction, and the International Affairs. As an NGO expert advisor since 1994, His Excellency Wanchai chairs 3 NGO working for promotion and protection of children's rights. He ably represented and negotiated on behalf of Thailand in the deliberation of several conventions, which includes, among others, the United Nations Convention Against Transnational Organized Crime and its supplemental instruments, which includes the United Nations Protocol on Trafficking in Persons. His outstanding efforts for women and children merited him 2 awards: an Outstanding Person Working for Women Award and a Person Working for Children in Field of Legal Protection and Children's Rights Award, given in 1998 and in the year 2000, respectively. His Excellency Wanchai, the floor is yours.
Thank you, Dalius, for a very nice introduction. Her Excellency Councillor Julian Ray, Director of the ASEAN-ACT, to all the panelists, Madame Bunlua and Sarah, distinguished participants. Today, I will present the part of ASEAN on the compensation, and then I will raise the example of the procedure in Thailand as well. See that the human trafficking in ASEAN mostly is a cross-border trafficking, and most of the victims of human trafficking are immigrants in the country of this crime happen, because they're seeking better economic opportunity abroad. And then when they're falling into the hand of the traffickers, the victims are not paid or underpaid for the works in case of labor exploitation. And for sexual exploitation, mostly are not paid at all, and they are told that they are in debt for the transportation and all other. They have to receive cases more than 500 or more in order to pay for the debt of transportation and all other arrangement before they can earn the money. And sometimes they will cheat it again after uh, receiving or achieving that number. They were sold to another traffickers and have to start paying debt again. So they are very suffers on this. More than that, in many cases, victims are detained and assaulted. Apart from rescuing them out of the hand of the criminals, how can the victim get compensation for their labors and suffering received from the traffickers? Next. In the ASEAN Convention Against Trafficking in Person, of which I am one of the drafting team, we thinking of this ASEAN Convention Against Trafficking in Person, or ACTIP, is one of the best regional convention against trafficking in persons. It is go beyond the trafficking protocol, especially in the part of providing assistance to the victims. It provides many assistance to the victims, and for the compensation, Article 14 in paragraph 13 states that each party shall ensure that its domestic legal system contain measures that offer victims of trafficking in person the possibility of obtaining compensation for damages suffered. This is the thing that it is the obligation for all 10 ASEAN countries that we have to provide access for victims to get compensation. However, it is very well founded principle throughout the world that compensation is the financial or properties that shall be obtained from the offender of the cases. So this system of getting compensation is a very old system that existing with the criminal justice since the beginning for a long time. We will discuss that again later. ACTIP also provide that the property of trafficker derived from trafficking shall be proceeds of crime and shall be confiscated by authority in Article 7 and 17. And when it is an obligation for all 10 countries to make the property derived from trafficking to be a proceed of crime, the proceed of crime or property confiscated from trafficker must be disposed of as prescribed by domestic law of each ASEAN member state. So it is based on the money laundering law of each ASEAN member state, how the property confiscated can be disposed. When acting on the request made by another ASEAN member state, the confiscated proceeds of crime or property should be returned in bracket if permitted by domestic law, so that the requesting country can give compensation and assistance to the victim of trafficking in person. This is the article that provided in ACTIP or ASEAN Convention. Next, please. And in order to implement this ASEAN Convention. ASEAN has organized and then draft the work plan, a regional plan of action in Bohol. So it's called the Bohol work plan in order to implement it, every aspect of the ASEAN Convention. However, if you look through the Bohol work plan, the Bohol work plan has no any specific plan on compensation. So this means that compensation shall be handled by domestic law of each country. Why the compensation was not listed in the Bohol work plan? I guess that the Bohol work plan work on the things that is not very well settled and what need to be done. However, in the compensation, it is a very well settled that each country have law to deal with the process of getting compensation. And it is very difficult to tell ASEAN member states to change their law. So the Bohol work plan has no specific plan on compensation. I think this is one of the gaps that we need to rethink about. We need to rethink if the Bohol work plan reached the end of it, and then I believe there will be another work plan to follow the Bohol work plan. And from the Bohol work plan, the Bohol work plan is one of the best work plan in terms of it assigned all the work to nearly every organization in ASEAN, every sectoral body, in order to implement it in accordance with the duty of each sectoral body. And there's a lot of projects that have been created in all the sectoral body in order to implement the Bohol work plan. However, most projects of ASEAN focus on identification, protection, support, and assistance to the theft victims on their need, gender, sensitivity, safe shelter, medical and mental care, safe repatriation, appropriate reintegration, legal assistance, and some financial assistance. But a few projects giving access to compensation was mentioned in a few projects. But there's no a specific project on compensation. Next, please. Thus, providing access to compensation nowadays relies on domestic law of each ASEAN member state. And one of the things that we have to think and work on is that there's no baseline study was conducted in ASEAN on the domestic law of each ASEAN member state or mechanism on how to get compensation for the victim of trafficking in person. What is the process in each country? What is the legal requirement or the legal process? Some countries, you can get the compensation from the criminal court. Some countries, you have to file separated cases in civil court. And that will add the difficulties to the victim of trafficking and the authority that assisting them. And compensation, as I mentioned, it is well filed for a long time since the beginning of the justice system. So they have a very strong base. It is very difficult to change them. I think it is time to have a project to address the access to compensation in ASEAN and to study best practices on policy, laws, regulation, challenge, and assistance provided to the victim to create a standard law practice in ASEAN. The recommendation to ASEAN, how can we change it? I think that if ASEAN-ACT interested, ASEAN-ACT Thailand is willing to start this project to conduct this baseline study on the process of getting compensation in each ASEAN member state and how they can cooperate in international cooperation for legal matter in order to get the compensation for victim who's in foreign country. Next, please. So let me give you the example of the process that we do in Thailand. In Thailand, we implemented the ASEAN, the active as well. And we believe that providing assistance to victims is one of the most important dimensions of the elimination of human trafficking, because without the cooperation of victims, it's next to impossible to punish the trafficker, because in most of the cases, the only eyewitness is the victim. So getting compensation from the offender to pay the victim is one way of helping the victim, and it is a way to encourage victim to be witness and to cooperate with authority and testify against the trafficker in court. So getting compensation for the victim needs appropriate policy, law, and mechanism to support this measure. Next, please. The Anti-Human Trafficking Act 2008 of Thailand provide many types of financial assistance to the victim of human trafficking. This includes assistance in legal proceedings to claim for compensation in accordance with the regulation set forth by the law. It means that the authority in Thailand will give them information on how to get compensation and to work with them in order to get compensation. And the authority will provide all the financial costs for hiring lawyer and court fee. However, it is in the criminal cases, no court fee is required. The victim and social worker, this is an obligation. The victim and social worker have to work together with the prosecutor of the case to assess the amount of compensation in accordance with the suffering that they receive, the loss of labor that they need to be paid. And then the prosecutor will file the claim for compensation together with the indictment in the criminal cases to the criminal court. Therefore, there's no need to file a separate case for compensation in a civil court, because we want to make it to be one-stop services. The criminal procedure of Thailand has been amended in order to get compensation to the victims of criminal cases in criminal court. Next, please. And in some cases, where appropriate, mean that if the offender is a company or factory that they have a property and it is very well filed, the Ministry of Social Development and Human Security may assist the victim by bringing them to the labor court, providing all the fee, and then providing lawyer for them in order to file a claim for unpaid wages in labor court. And in many cases, we get success for the wages that unpaid and all the compensation to the victim. The Anti-Human Trafficking Act also establishes the Anti-Human Trafficking Fund within the Ministry of Social Development and Human Security for providing all kinds of assistance to the victim, including daily allowance during stay in shelter, legal fee in case of lawyer is needed, and financial redress to the victim or their repatriation. The Ministry of Justice also have a law to providing financial redress to the victim of trafficking and other crime as well. But the redress is limited in amount of money, and we do not consider that to be compensation. It's a part of compensation provided by state, but not a real compensation. They also have the right to get compensation from the victim as well. Next, please. The problem and challenge that often occur in getting compensation as ordered by the court, as mentioned by Madame Bulua, is that the offender does not have money or assets to be confiscated for paying the compensation to the victim. So in many cases, the victim get the court order that they entitled to compensation to in a certain amount, but the offender have no any means to pay for that. The crime of human trafficking is prescribed by the Anti-Human Trafficking Act as a predicate offense. The Anti-Money Laundering Office can confiscate all the money and assets of the offender deriving from the crime of human trafficking. But in most cases, the trafficker have no assets to be confiscated. While we have in a few cases that they have a lot of money and assets that deriving from the trafficking crime, that we can confiscate it more than the amount of compensation needed. Next, please. So in order to solve this problem, the government is now in the process of amending the Anti-Money Laundering Act to put all the confiscated money from and assets from all human trafficking cases into the Anti-Human Trafficking Fund. And this will be separated in the Anti-Human Trafficking for paying to the victim of all trafficking cases, not only in the cases where the asset is seized and confiscated. So providing the compensation to the victim is the fundamental measure and right that should be done in all cases. Thank you. Thank you for your attention.
Thank you very much, His Excellency Wan Chai. Very comprehensive and insightful presentation. Thank you for giving us a broader view of the obligations under ACT and the respective domestic laws in providing access and obtaining victim compensation. We agree with you that providing access to victims by giving compensation is a fundamental measure, and there is a need to have the legal framework to support it. And thank you for also sharing with us that even that the money laundering law is part of that framework to support victim compensation. So, on to our last and certainly not the least speaker to discuss on the topic from an international perspective. Sarah Vessel is the Deputy Director at the Human Trafficking Legal Center, where she provides training and technical assistance for immigration and civil human trafficking cases. Ms. Sarah also conducts research on accountability for human trafficking victims and has authored publications on the intersection between human trafficking and corruption, diplomatic immunity, persons with disabilities, and domestic violence. She also manages the Human Trafficking Legal Center International Strategic Litigation Program. Ms. Sarah has a background in international human rights and conflict prevention. She also spent time in Cambodia, where she worked in the office of the International Co-Prosecutor of the Khmer Rouge Tribunal. You now have the floor, Sarah.
Thank you so much, Darlene, and all for inviting me to be with you all today. I'm so excited to be sharing the US perspective as well as the NGO perspective on compensation for victims. And let me just share my screen 1 second. All right, can you all see? Oh, wait, let me, 1 second. All right, it should, can you all see my screen? Excellent. All right. And apologies, I think I just want to be able to, okay, there. I'm loading the chat so that I can see the prompting when I come up on 5, 10, and et cetera minutes. So hello, everyone. Again, I'm Sarah Bessel, Deputy Director of the Human Trafficking Legal Center based in Washington, D.C. We're a nonprofit organization that works to provide legal access to justice for human trafficking survivors in the United States. And as I said, I'm glad to be here today to share the US model, which is by no means the only or the best model, but we're here today to share that, as well as the NGO perspective on its implementation in the United States. Oh, excuse me. Okay. The Human Trafficking Legal Center, as I mentioned, is a legal nonprofit, and our mission is to enable survivors that wish to pursue legal remedies to have skilled pro bono lawyers, because we believe that when survivors have lawyers, survivors have rights. And our model focuses on training and technical assistance for attorneys in the pro bono sector, as well as NGO attorneys. And our model works on a pro bono referral model. So we have outreach programs to NGOs who reach out to us when they identify a survivor who has potential legal needs. And then we pair them with a pro bono attorney, and we provide mentoring to that attorney during the lifetime of their case. And in addition to that casework, we also do extensive research into human trafficking research areas, and use that to drive not only our training, but our strategic litigations programs as well. So just a little overview about our work beyond compensation. So the international standards from which the US derives the compensation for trafficking survivors, we derive it from the Palermo Protocol, which as His Excellency noted with the ASEAN-ACT tip, that it actually is word for word from the Palermo Protocol as well. So it comes from Article 6 of that international document. And in terms of how the US implements this particular obligation in terms of compensation for trafficking survivors, today I'll talk about the criminal procedure as well as the civil procedure. And I'll be focusing exclusively on the US federal system, and not really delving into individual states in the United States and how individual states approach this issue, although that is also a topic that we could go into at great length. A little bit of difference between the US criminal and civil system. Under the criminal procedure, we are pursuing criminal restitution for our clients, and in the civil system, we're pursuing civil damages. They are distinct systems. You do not need to file one to pursue the other. And then often is the case, you can have both proceed, you can have both for one victim, although that is not often the case, as I'll show with our data. A quick overview of US federal law. US federal law has a distinct statute that penalizes and criminalizes sex trafficking. We also have a standalone statute that penalizes forced labor. And thirdly, a standalone statute that penalizes human trafficking as well. So we have distinct elements for each crime. Also built into our federal anti-trafficking law is 18 U.S.C. 1593, which is our mandatory restitution provision. Congress built into our federal anti-trafficking laws that trafficking victims, victim witnesses in criminal procedures should be awarded mandatory restitution for the full amount of the victim's losses. And now this includes past losses as well as future losses. And I've seen some questions in the Q&A box about how to prove that up. And usually you would do that through, in terms of past losses, receipts. And in the case of future losses, you would need to get expert testimony. So there's one case in which we often lecture on, a sex trafficking case involving minor sex trafficking victims. And the guardian ad litem appointed to the child victims argued to the court that the victims should be compensated under the mandatory restitution provision for future losses due to lost income, education, etc. This guardian ad litem was able to actually get several experts to provide expert testimony to convince the court that they should award restitution to these victims for future losses as well, which the court did. The mandatory restitution provision covers, in addition to past and future losses, that includes out-of-pocket expenses And here's a list of examples that we have seen courts order in terms of restitution orders. Again, I've seen some questions coming in as how to convince the court, how to prove that up. In this instance, you would need to usually show receipts or some proof that, for instance, there was lost income or medical services were paid out of pocket by the victim due to injuries resulting from their specific trafficking incident. I would note here that the forms that you have to fill out as a victim to prove restitution can be quite arduous and can be quite complicated, which is why we're constantly pushing for all victims in criminal proceedings to have lawyers to represent them or to have case managers who are keeping their best interests in mind. You have victim witness coordinators within prosecutors' offices all across the country who also can provide help in filling out these forms. But again, we always advocate that victims have advocates at their side who can help them gather this information. And a lot of times in many jurisdictions, criminal prosecutions take a very long time. And so it's a matter of educating your client on the fact that even though in this day and now you're not thinking about the trial 3 years down the line, it's necessary to keep those receipts, keep all the records, keep all the copies, and to fill out that paperwork. And another component of mandatory restitution is earnings. And so Congress actually made it easy for the courts, and they built into the statute a formula. So when a court is assessing earnings to grant to a trafficking survivor, they either look at the wage standards set under the Fair Labor Standards Act, and then they also assess how much the defendant earned from the forced labor or the forced commercial sex of their victim. They take those two figures, and then whatever is the greater figure, that's what they award the earnings for. And it's already been well litigated in US courts in terms of sex trafficking cases that even though prostitution is illegal in the United States, a defendant earning profits from proceeds from commercial sex, forced commercial sex of a victim, shouldn't be able to profit from that, shouldn't be able to benefit from that. So even a sex trafficking victim who has been forced into the illegal act of prostitution in the United States, the court would still order the defendant in that case to pay back the victim whatever he or she earned from that forced sex. So in one case example, and I have a couple of case examples that I want to go into today, this is a forced labor case in Ohio in which a group of individuals created a scheme to recruit minors from Central America, from Guatemala, and they smuggled them into the United States. They presented them at the border as unaccompanied minors, and then the traffickers actually came forward and posed as relatives, posed as foster parents to actually have the unaccompanied minors placed with them. And then they had promised these minors the ability to work, but good working conditions, and also the ability to go to school. But as is often the case in these, cases, they forced the minors to work long hours in egg farms, collecting eggs in horrible conditions for low wages. This is actually a picture of one of the bunkers that the miners were forced to live in. So they were living and working in very squalid conditions. Eventually, due to an investigation, the scheme was found out and the group was prosecuted. And during the course of that prosecution, the court ordered the defendants to pay the victims restitution in the amount of roughly 67,000 USD. Another case that we've seen restitution ordered is a case involving a domestic worker, what we term domestic servitude cases in the United States. And this involved a woman who brought a domestic worker to the US from China and forced her to work long hours with little pay, confiscated her passport so she could not run away, and also subjected her to very intense physical violence and beatings. An interesting point of this particular case, you can see that the final restitution order was roughly 123,000 USD. As part of the defendant's plea agreement, she actually agreed to pay a portion of that restitution order up front. So I also saw a question that talked about a collection, and that is that's one tactic in which prosecutors in the US can try and ensure that they get partial compensation or satisfaction of a restitution, is by building it into a plea agreement up front. Another labor trafficking case is US v. Kizzy Kalu, and this is a case involving nurses from the Philippines, highly skilled nurses who were recruited to the US with fake promises of being professors in a university. And instead they were forced to work below their skill level. Oh, I'm so sorry. I just saw the note about my speed. I will slow down. Their skill level. And in this instance, the court ordered Kizzy Kalu, the defendant, to pay this group of victims $3.7 million in restitution, which is a considerable restitution order that we've in these cases. However, that looks good on paper, but what is the reality? Well, our most recent research from 2013 shows that an assessment of federal criminal trafficking cases shows that mandatory restitution is actually only ordered in about 27% of cases. Now, there are a variety of reasons for this. In some cases, it could be that the judge is not as familiar with trafficking cases and with the mandatory restitution provision. We have also seen that prosecutors feel that if a defendant is indigent, if they don't have enough assets to satisfy a restitution order, they don't feel the need to ask for the order in the first place. Although we would argue, our position is that prosecutors, regardless of the financial status of the defendant, should always request the restitution order because the mandatory restitution order is outstanding for the rest of the defendant's life. And so we have seen a few rare cases in which the defendant comes into assets further down the line and it's brought to the court's attention, and then the court orders the defendant to satisfy their restitution order. However, also in reality, so as I said, about 27% of cases only result in restitution, even though it's mandatory. And we see in this case of US v. Shackelford that even though there was a criminal prosecution, no restitution was ordered. And so one way to get around, one way that we have worked, and we've also noticed in our research that the victim demographic least likely to receive compensation in a criminal proceeding are child victims of sex trafficking. And someone had asked in the Q&A about what about reporting? Are governments required to report? The US Attorneys General has to, from the Department of Justice, is required every year to report on the amount of restitution collected compared to the amount of restitution ordered. And as you can see from the figures on the screen, the rate of collection is quite low. In FY 2018, it barely reached 10% of restitution orders was actually collected. One way that advocates have attempted to remedy this is something similar to what His Excellency was discussing, is forfeited assets. So in 2015, advocates changed the law so that any forfeited assets in a trafficking case must go to satisfy a restitution order first before being used to pay any other creditor or to fines of the US government. So this is a sex trafficking case involving a ring of defendants. And in this case, the government forfeited and sold forfeited property in the amount of about $300,000. And they were able to use that $300,000 to partially satisfy a restitution order of about over $1 million. I'm coming up on time, and I had hoped to be able to get to the civil side of things, but it is in the slides and I know that they are being distributed. But a real quick note that federal criminal trafficking cases are not can't be the only way in which we rely on getting compensation for trafficking survivors in the US, because as you can see from this chart, there are very few trafficking criminal cases in the United States in any given year. It hasn't even breached 300 in the past 5 years. And so there's more information in the slides about civil remedies and how that can also be used to pursue compensation. And I'm happy to answer questions in the Q&A, but I see my time is up and I'll yield the floor.
Thank you very much, Sarah, for that comprehensive presentation. The discussion on international cases was very informative and provided us insights on the processes the victims have to go through in the US justice system. It was also interesting to see the contrast between the restitution ordered by the court and those actually collected by the survivors or received by the survivors. It is actually not uncommon, as in the ASEAN region, there are a lot of countries like even Philippines or Indonesia and others where we see paper convictions and victims receiving nothing from the awards given by the court. Okay, on our next session, we have actually three parts. First, we'll show you the poll results and seek the reaction of our speakers. Second, we'll show short videos of a survivor and an NGO lawyer, and our speakers will likewise give their reactions to one or two of those videos. Then third, we proceed to read and answer some questions from the Q&A box, considering that I don't think we have enough time to read all the questions. Cam will share the polls again, the poll results, and we see the final results here. I hope everybody can see it. Can everybody see it? Okay. The first question here, or the poll results for the first question is, it appears that yes got the highest, that many agrees that compensation should be dependent on victim pursuing a legal case against the perpetrator. And only 27% said no, and 8% who said somewhat. May I invite Madame Bunlua to give her reaction on this poll result?
เจ้าขอบใจดารินเนาะสำหรับคำถาม
Thank you, Darlene, for the question, particularly for those who are interested in this claim for compensation to the victim. Of course, we must base on the claim of the victim or not for this. From my perspective, claiming for civil compensation is the right of the victim as enshrined in the domestic laws. However, claiming for compensation, if we base on the claim of the victim themselves, we also need to rely on the degree of the damages or the degree of the suffered. We not only can look at one dimension or only look at the written claim of the victim. So we need to, for example, if they claim too high, that is not proportionate to the damage, actual damage, and then it may not be able to implement, or it may create unsatisfaction for the perpetrator to pay. Therefore, this claim may not be implementable. So we need to look between the claim by the victim, and also we need to look at the degree or magnitudes of the damage or the suffering, or for example, how much medical payment, how much the potential or the work that have not been unpaid, that are unpaid, as the basis for deciding the amount of compensation. Thank you.
Thank you, Madame Bonlua. Can we now proceed to question 2? In question 2, we can see that the yes and no more or less have the similar percentage. Many yes has 45% who agrees that compensation should be dependent on a criminal conviction of the accused, and 47% actually said no, higher than the yes, and only 8% somewhat. May we request His Excellency Wan Chai, being a veteran prosecutor on trafficking purposes, may we seek your reaction on the poll results?
Thank you, Darlene. In this, I will answer on the legal aspect because, as I mentioned, compensation is a very old thing that existed since the start of the legal system. So because when someone causing damages to another, then they have the obligation to pay compensation to the victims. However, I think that if the court does not convict that they committed offense, it's very difficult to get compensation in the legal principles, according to the legal principle. So I think that in the majority of countries around the world, that the victim compensation, depending on the criminal conviction of the accused, except that in some cases where the fact is quite clear that they have done some damages too, but on technicality or some things that, but that's very rare case, and I don't want to mention that. Another dimension said that the victim who suffers already a lot, being detained or whatsoever, the compensation can be given to them in the cases by state, yes, that we call a redress. It's a partial compensation, but not the real compensation. The full compensation must be paid by the victims, by the offender. So I think that in this case, if you look at the legal system all around the world, the victim compensation still depend on the criminal conviction of the accused. Thank you.
Thank you, His Excellency Yuan Chai. On to our third. As we can see, that it's kind of related, all of these questions. So as you can see in the third, 76% said yes. So many agrees that there should be a regional standard to claim compensation from a state fund, with only 10% saying no and 14% kind of unsure. Sarah, may we hear your thoughts on this?
I think the poll answers do track with a growing and emerging consensus among anti-trafficking advocates that there needs to be some type of state fund for compensation. One thing I didn't mention in the US context is that there's currently no designated federal trafficking victim state fund that trafficking victims can apply to. That is separate from the victim assistance funding that they receive, that foreign workers might receive if they're identified. But we're starting to see movement more among the different states in the United States towards victim compensation funds. And actually in the related sphere of child pornography, recently the Child Pornography Victims Reserve Fund was founded, in which would enable victims of child pornography trafficking to be entitled to requesting and receiving a one-time payment of $35,000 USD from this fund instead of fighting for restitution. They would have to choose between the two. But in that case, that is an alternative where the defendant, as many in the audience have pointed out in the Q&A, don't have assets or are asset proof. Now, from what I last remember, this fund, I don't believe, is funded up too much. So state funds do rely on political will to actually devote funding, appropriate funding, to these types of state funds. So it can't just be on paper. We also need to be pushing states to put the money into these funds to enable victims to have compensation.
Thank you very much, Sarah, and to all our participants for putting in your thoughts through the poll. So the reactions from our speakers were all very helpful, so thank you. We move to part two. The second part is quite as exciting, knowing how important it is to hear the voices of victim survivors. Let us listen to this short video from a survivor, Myrna, not her real name, who has never filed a case nor participated in the legal process. Her journey to obtaining financial assistance in a form of a grant took quite some time. She have given her written consent to share her message to everyone. Let's listen to Myrna.
Myrna, nabanggit mo na hindi ka lang na-traffic doon sa ibang bansa, kundi pati dito. So, nung mga panahong yun, ano yung mga inasahan mo na tulong? Or may naasahan ka bang tulong nung time na yun? Pwede bang pakibahagi mo yung sa abroad at saka dito?
Kasi third time talaga, napakasakit na nangyari sa akin. Lahat yata ng karanasan na masakit na naranasan ko na po. Natraffic ako sa ibang bansa, hindi lang sa ibang bansa, bakit sa Pilipinas po. Sana yung time na yun, may tumutulong sa akin. Sana maparusaan yung mga na nangyarabyado sa akin. Na nagkaroon ng boses na tulad ko na biktima, nagkaroon ng boses po. Patuloy ang mga nabibiktima sa ngayon kasi sa ating bansa, patuloy pa yung nabibiktima na katulad ng pamamayan. Sana sila nabigyan ng kaparusaan at nagkasala at para hindi sila pamarisan lang po. Sana mabigyan sila ng mga training o kaya buhay sa bulan natin o pang-umpisang pagkabuhayan. Ang pagkalam ko po mayroong pundo sa ganyan na po nangyayari sa mga biktimang tulad ko. Wala naman nakarating sa akin, wala po akong tulungan. Saan nagpunta yung pundo ko kaya sa tulad mo po? Yun po, maraming salamat po, ma'am.
Salamat, Mirna.
All right. We'll play the second video before we hear the reactions. So our second video features Attorney Jewel de la Cruz, the Senior Lead International Collaboration Center to End Online Sexual Exploitation of Children of the International Justice Mission Philippines. The Center to End OSEC is part of IJM's Global Online Sexual Exploitation of Children Hub, which elevates and scales promising practices and models online sexual exploitation of children around the world. Attorney Jewel was able to assist survivors obtain compensation from a foreign jurisdiction. So let us hear her message, please.
What is your view on securing compensation from different jurisdictions? In our organization, the IJM, we have supported restitution claims in the United States, and now we are supporting one in Australia, meaning the victims are here in the Philippines, that there is a local perpetrator here in the Philippines, but there also is a foreign perpetrator, meaning he's on that demand side. He is the customer, the end user of those child sexual abuse materials. And we have seen US courts award a significant sum of money to trafficking survivors. And this significant amount of money allowed the survivors to start secured life. 2 survivors, in fact, has finished college using the money, this restitution award that they got before US courts. Now they are licensed social workers and are able to pursue even further studies using this restitution claim. So it's a hopeful story. But again, the process can get long and tedious. We have supported the government partners securing a psychological evaluation certificates in order to back up this restitution calculation that we have computed. Of course, again, what I mentioned a while ago, the victim impact statement. Again, the process can get complex, but it is doable, as we have seen in action. Among others, there must be solid coordination from parties, foreign prosecutor, foreign law enforcement, law enforcement, the local Department of Social Work, and of course, the survivors themselves. So it might be complex, it might be tedious, but this foreign victim compensation awards, they can happen, and we have seen them happen.
All right, so may we hear from our speakers, His Excellency Wan Chai, Ms. Sara, and Madam Bundua. What are your thoughts on any of these videos? You may react to one or both of the videos. Just be mindful of our time limits. Thank you. Do we hear anyone from any volunteer to go first?
Who first?
Yes, please.
Yes, I think that compensations is an obligation of the government on 2 parts. The first one, state can provide compensation to the victims, but not all, because the limitation of the ability of state to provide, they can provide partial, that what I call redress. I prefer to call it redress more than compensation. And the second thing, that state have to have the obligation to assist victim to get access to a legal process or whatever to get compensations. And according to the law of Thailand, it is an obligation that the social worker and prosecutor have to consult with the victims and provide and file a claim for compensation to every cases, in every cases. So it is now very well settled now. For the getting compensation in a foreign court, you need a cooperation with organization in another country. I think it can be done if there's what do you call agreement or MOU, or even I used to work with NGO that as an NGO, I used to work with NGO in Sweden, Red Banner, in order to file a claim in Swedish court, and Swedish court award compensation to Thai victims that were abused in Thailand, and the offender abscond and returned it to Sweden. We brought the child to Sweden, and the Swedish prosecutor, with the help assist of Red Banner, filed criminal court together with file claim for compensation in Swedish court, and we get that compensation for the child. It's a very good example. I think yes, I agree that it's doable, but it's a bit difficult and costly. Thank you.
Thank you, His Excellency. Your thoughts, Sarah and Ms. Wunlua?
ขอบใจเนาะสำหรับวิดีโอค่ะ
Thank you for the video clip, especially the sound of the victim is the basis, is the fundamental, because we must be informed of the basic information of the victim, what kind of damages they have, in order to consider to claim for civil compensation. The important aspect, particularly those who are providing legal support or protection, we need to help, to need work together and enable the victim to get access, try to not to take advantage of them. However, the compensation, like the case taken in other country, we need the cooperation from both parties, as Excellency Wansai mentioned. We also based on the bilateral MOU or based on cooperation with multilateral organization, INGO, how to lead the victim to join the court hearing or in other country, so that they get access to and manage to get the compensation. The important part is that we need to join hand domestically or regionally, internationally, so that the victim will not be disadvantaged and can benefit from what have been defined by the law. Thank you.
Thank you, Madam Bondua. Sarah, your thoughts?
I would echo what's already been said in terms of Myrna's case about the importance of, be it civil remedies or a compensation fund that is not dependent on the criminal process, some alternative mechanism beyond the criminal justice system to enable or allow a survivor to access compensation. Because as Myrna's story says, if we just rely on the criminal justice system, as is so often the case in many of our jurisdictions, survivors will never have access to compensation because of whatever reasons, lack of political will, resources, prosecutorial discretion. And so I would echo what was just said about the need for civil litigation in that respect. And then, the comments from my colleague from IJM were so inspiring. And I think it is also impressing upon the need for all of us to stay coordinated And there are many groups that are doing amazing work in the area of cross-border litigation on behalf of trafficking survivors, Justice Without Borders working on behalf of domestic workers, Liberty Shared's legal hubs around the region, Trust Law. Our own organization at the Human Trafficking Legal Center can connect your clients with litigators in the United States if there's a connection to the US, as in the example with IJM. And so I think we need to continue building those connections and communities between us so that we can ensure that borders really should not be a barrier to accessing compensation.
Thank you very much, Sarah. And thank you to all of our speakers for your candid reactions. Those were very helpful. And Myrna, when she shared her video and message, she said that if she can help, if her message can bring out that that needs to be heard by those who are in a position to put in the right framework, as His Excellency has mentioned, then she would really be happy. So right, for Myrna, yes, she never participated in the legal process, while the IJM video, it was really through the legal process. Both works, both can be still be helpful. But thank you, Sarah, for your reaction on that, and of course, Madam Bonlua. And now on to our part 3. We are running out of time. We only have around less than 20 minutes for our awaited Q&A portion. May I give the floor to Kem to read some questions from our attendees. We may not be able to read all of the questions, but we will try to answer them. And of course, to hear from our speakers to reply to your answers. Kem, please.
Thank you so much, Darlene, and to our dear panelists. We have a number of stimulating and intriguing questions. And the first question I'm going to throw respectfully to Sarah, because you touched upon this in your presentation. And it goes, does compensation always mean monetary compensation, or does it include long-term psychological or psychiatric services to trafficking victims? This was asked by, I think, 3 attendees in the webinar. Sarah, please.
Absolutely. So in the US context, it would be a 2-step process. It would be requesting compensation, requesting restitution or civil damages in order to then fund the psychiatric services. So it's not that the courts would actually arrange and appoint a psychologist or a counselor to the victim. It would be an assessment of the survivor, of the plaintiff or the victim witness by a psychological expert, arguing that yes, based on that expert opinion, they do need X amount of years of trauma counseling in order to help them overcome the trauma of their counseling. That can be that number, that cost of that would be X, and then you build that either into your damages request or you build it into the restitution order. So that's how it would work in the US context.
Thank you so much, Sarah. May I also ask Kunwan Chai, what is the experience in Thailand as regards restitution for psychological or psychiatric services as part of the restitution, sir?
I think it is the same as all over the world, that you cannot rely on the offender to pay periodically for the treatment or psychological treatment of the victims. The way is that we have to assess how much money needed for our whole process of psychological treatment, and then calculate it into the term of money and get the money from the offender to pay to the victim in order to pay for not only for the damages but for psychological treatment, a long-term psychological treatment as well. Because if you rely on the offender to pay for the treatment periodically, if they don't pay, then the victim will have a problem. So this is, I think, is very well settled all over the world. But the victim can get compensation for psychological treatment, no matter how long it is. Thank you.
Thank you so much. I think in some jurisdictions, it is called moral damages as part of compensation and restitution award. Is it the same experience in Laos? May we hear from Madam Bunlo?
เจ้าข้าพเจ้าคิดว่าการ
I think claiming for mental compensation and claiming for compensation is quite similar to international practice. However, in Lao PDR, we claim the claim for compensation. We don't have laws or regulation specifically. However, we just assess the civil compensation to the victim. Firstly, we base on the written claim from the victim themselves. It does not mean they claim that much they will receive that amount. We need to consider the actual damage caused by the perpetrator. For example, if it is the labor that unpaid, or any psycho damage, or the opportunity cost, or for example medical treatment happen in the course of that being suffered, to be the basis for computing what should be the proportionate. On the other hand, it also based on the agreement of both parties, both the victim and or the representative of the perpetrator, so that can lead some kind of agreement.
So much, Madam Bundo. Now I'm going to ask another question, and I'm going to ask first the prosecutor amongst our panelists, Kun Wan Chai. There is a question about court process. It says that what do you do if, say, in the proceedings, the defense counsel attacks the victim by saying that you're giving false testimony so that you can get compensation, and that the testimony and the of the victim, the relation of what happened from the victim is because the victim wants to get compensation. Your reaction, sir?
It is well founded in the legal process of every country. As I said, that the claiming for compensation is as old as the legal system. Every criminal cases, the victim always claim for compensation because they're entitled to. So it is the very unlogical question to ask the victim like that. However, normally we will tell the victims to tell the truth, because the truth is the most important thing in court. So whenever our victims encounter that kind of question, they will say, "No, I speak the truth, but the right to get compensation is my right," something like that. And also in Thailand, we do not use any the ordinary criminal court to consider the trafficking case, because we have a trafficking section in the criminal court that we train all the judges to understand the process of criminal of human trafficking, and they know the pride and the weakness of the victim when encounter with criminal lawyer. So in Thailand, we do not have such a problem happen in Thai court.
Thank you so much, Kun Wan Chai. And how about you, Sarah? Would you object to this line of questioning? It seems to be asking for an opinion. If you were representing the victim in this case, what would you say?
Well, I would actually say that we have seen less defendants less saying you're giving false testimony in order to get compensation, and more usually in the context where the victim is a foreign migrant worker. We see defendants commonly raise the argument that the survivor is only pursuing a lawsuit or filing criminal charges because they want immigration status in the US. So we deal with a slightly different defense here in the United States, which is quite common, and it's kind of part of the defendant's playbook now. And so plaintiffs' attorneys and victims' attorneys now know how to rebut that argument.
Thank you. I love a good rebuttal, Sarah, in court hearings. We go to Lao PDR now, to our panelist, Madam Bunlua. Maybe you can answer this question first. Do you have compensation guidelines in your country?
อยู่ลาวมีบทแนะนำในการค่าชดเชย
And
บ่มี
how
บ่
does your government handle and monitor the
รัฐ
compensation
บาลติด
provided
ตา
to the
ม
victims of
เรื่อง
trafficking,
การชดเชยคือแนวใด
especially if the compensation
โดยเฉ
is
พาะถ้า
from a foreign
ขอโทษ
country?
เจ้าสำหรับอยู่สปปลาวพวกเฮา
In
แม่น
Lao PDR the process so we have written legislation or we don't have written policy or legislation on civil compensation. However, we said the victim have the right to get redress or compensation, but we have step to support. For example, step to provide legal support to the victim of trafficking in person, particularly in the guideline for the protection, support, and referral of the victim. So we have the step. What should we do, particular even in Laos or in other countries? So we have to follow that guideline on victim support. However, we don't have specific legislation for compensation. As I said, we have first be based on the claim by the complaint by the victim against the perpetrator or the suspect. Second, we have to look at the magnitudes of the damages in case this happen abroad. So we monitor since the beginning until the justice process concluded. For example, joining the interview to get testimony from the victim, what damage they have. After that, we prepare the victim as well as to draft certain legal provision for claiming civil damage to them, and then provide some documentation to comply with the requirement of other country, and then we submit to other country relevant stakeholders. As I said, we follow MOU for our cooperation, and we need to coordinate directly, like the case in Thailand. So we have been working directly with Ministry of Social Development and Human Security, particularly for documentation purpose. So we coordinate with them. We use both way, right? Formal or informational to share information on receiving or claiming for civil compensation to the victim until the justice process completed, until they get compensation from abroad.
Thank you so much, Manam Bundo. May we also have the reaction of Kun Wan Chai about that question of guidelines? Sir, if you can share the guidelines of Thailand, what are these guidelines? And also, if you can address Kun Wan Chai one question from the participant, if it is already time to have a regional guidelines on compensation that ASEAN member states can agree on and perhaps can look into when they are crafting their own domestic compensation guidelines. Kun Wan Chai, please.
Yes, I think there should be a guideline and or what we call good practices for all 10 ASEAN countries. But however, I think that we need a series of projects. First of all, we need to have a baseline study on the law and practices in all the 10 countries. And then we will have what you call maybe a working group in ASEAN in order to getting good practice and then map up the good guideline that on compensation, and then taking all the good practices of in the 10 countries to put in the guidelines so that the other member state can think of. Some they can do it without changing the law. Some they need to amend the law. Some they need to change the policy and maybe regulation. So I think it is doable, but I think that it should be supported by ASEAN-ACT. I think that it is doable.
Thank you so much, Kunwan Chai. I think we will take note of that one and consider that also as a challenge, perhaps one of the steps that we could take after this webinar. Unfortunately, we have very limited time, and just to manage our time well, we have a number of questions still, really interesting and intriguing questions that we have. But I'll give the floor back to Darlene to move on to the next item in the agenda. Thank you so much to our dear panelists, Sarah, Kunwan Chai, and Madame Bunloa, for answering the questions from our participants. And to our participants, apologies if your question has not been taken up. We will do our best to address those questions later on. Hopefully, we can give them to our panelists if they can find time. At this point, Darlene, you have the floor back.
Thank you very much, Cam, and to our esteemed panelists. And to our attendees, thank you very much for your thought-provoking questions. But before we close this session, His Excellency Wan Chai, Madame Budlua, and Ms. Sarah, would you like to share any last message to our attendees? Sarah, would you like to go first?
I'm happy to. I think as we've learned from today, there are some similarities across our different countries, but also differences as well. And I think we have a lot to learn from each other, especially as we grapple with this issue of even when you have compensation orders, how do you actually secure that compensation for victims as well? So I think we have a lot to think about, and I look forward to collaborating with you all on the call as we address this issue in the future.
Madame Bondua.
เจ้าคิดว่าการข้าพเจ้าก็ยินดี
I couldn't agree more with Sarah's comment because trafficking in person is happening globally, and it is very dangerous to the human being, to the region, to Lampida. So we need to work hand in hand to stop and to suppress the trafficking in person cases by means of sharing information, technical information, the best practice, the lesson learned, how to respond to these crime, so that all of us will be able to learn to have required legislation or proper policy which are timely to particularly the modus operandi of trafficking in persons will be changing, and will be therefore we need to work together to address them. Yeah.
Thank you, Madame Budlua. And your last word, His Excellency Wan Chai.
Yes, thank you. I think that for me, I think that the compensation to the victims should not be optional. It should be an obligation, and every country have an obligation to get compensation to the victims by providing them with by consulting the victims on how much compensation should be, judging from all the suffering and all the circumstances in the cases, and then file for compensation in the court in every cases. So we will get the court order for compensation. That's one thing. Then we deal with the challenge on how to get the money from the offender to pay compensation. Is that the things that we need to improve or the process? And also not only in a domestic one, but how to get compensation in a foreign court as well, how to cooperate between countries. So I think that we need to things, especially in ASEAN, study the legal basis on basic in each country, and then drafting a guideline on how to suggesting it should be compulsory, not optional, in getting compensation, and then how to get money to pay for compensation, including cooperation with foreign country in getting compensation. In this regard, Thailand ACDC is more than willing to work with ASEAN-ACT in creating the project on this series. Maybe together with the Philippines, we can go do project together and make this a reality in order to get the good practice guideline in ASEAN. Thank you.
Thank you very much, His Excellency. We couldn't agree with you more, and with Sarah and Madame Bonju. So thank you very much to our esteemed panelists for the very rich discussion and for the excellent advices. You have given our participants a lot to think about. So our heartfelt thanks goes to all of you. Now, to formally close our webinar, may I invite our team leader, Lucia Pietro-Pauli, to share her closing remarks.
Thank you so much, Darlene. I have the pleasure of closing this webinar, although it does feel premature because this discussion is so rich. I feel like there's more to talk about and this exchange really could go on all day. I hope this virtual event has been as useful for you as it has been for me. I've certainly learned a great deal from this last hour and a half. And it's really inspiring to see such a diverse range of policymakers, practitioners, and advocates and researchers all gathered online with such an interest in this very complex topic, that of the right for victims of trafficking to access compensation. I'd like to sincerely thank our panelists for their very thought-provoking and well-considered presentations, and for generously dedicating your time to us today, taking time out of your very busy schedules. Madam Bunla Chanhapoma, His Excellency Wanchai Wutjatla Wawung, and Sarah Vessel. You all provided us with very unique and nuanced perspectives on this complex issue of victim compensation. And I think it's really clear that we have much to learn from sharing our experiences across the ASEAN region and globally. It was very apparent throughout the presentations that although we all work in different jurisdictions, the challenges that victims and advocates face in accessing compensation are quite similar. But whether we're in Laos, PDR, in Thailand, or the US, it was very pleasing to see momentum building around this issue and to see some real world and practical examples of victims of trafficking accessing compensation that has enhanced their lives and assisted their recovery and reintegration back into society. It was also really pleasing to see, and very critical actually, to see the role of CSOs in working together with the judiciary to ensure better access to compensation for victims. So I'd like to thank again all of our speakers. I'd also like to thank the Australian Mission to ASEAN and our ASEAN member states for participating and for their contributions today. And I'd also like to thank my team, in particular Darlene Pajarito, who is the brains behind this excellent webinar series. Lastly, thank you to all of you for your excellent contributions through the chat. We will endeavour to answer all of your questions in some form, and for participating in our poll today. We look forward to seeing you all at our next webinar, webinar 8, which will focus on the issue of human trafficking in the 4th Industrial Revolution, where we'll consider how we protect trafficked victims and others at risk, especially children, in the digital age. So a very timely and relevant topic. We look forward to seeing you then. Thank you very much again, and good afternoon or good evening, good morning, depending on wherever you are. Thank you.
Thank you very much, Lucia Pietro-Pauli. I couldn't have done this without the whole team's work and support. So thank you everyone for helping me this webinar become a successful one. Thank you. But indeed, this webinar ended in a high note, big attendance, and lots of excellent sharing today. We'd love to hear your feedback. Please click on the feedback link in the chat box before you leave. Just give a few minutes to fill it up, and then continue to stay safe, and see you in our next webinar on September 17. Bye, everyone.